Hi everyone, Joe Gentili from Saroff Gentili LLP. Today I want to talk about when we file mandamus lawsuits on behalf of immigrants to help them deal with unreasonable delays. One thing we always do is we include in the mandamus complaint a count under the Administrative Procedures Act, otherwise known as the APA. So what a count is when you write a complaint, you got to point out the laws that you're relying on when you're asking the judge to do something for you. So of course there's a writ of mandamus, but also we include another count with the APA. And they largely do the same thing in this regard. We're saying there's an unreasonable delay, and the agency, whether it's USCIS or the Department of State, if it's a consular issue, they have a duty to act and they're not doing it, so judge, make them act. But this area of law it's largely administrative law, and administrative law has a lot of little quirks to it that are easy to miss if you're not familiar with it. And so there's really two reasons why we include that APA claim. So to win on a mandamus lawsuit, one of the things that you have to show is that you, the immigrant plaintiff, have no other adequate remedy available to them to solve the problem. There's no other way for you to solve the problem other than the mandamus lawsuit. And sometimes the government has been successful saying, if it's only a mandamus count, that, well, wait, there's this other law out there, the APA, which does pretty close to the same thing. So judge, they do have an adequate remedy. It's the APA. So we foreclose that argument by having both in one complaint. So this way they can't argue that there's some other remedy available that we're not bringing. The second thing is there's this other little kind of quirk in administrative law. It's a concept called exhaustion of remedies, which basically says that before you can get a court to review what an agency like USCIS does, you have to go through kind of these like internal appeals and give the agency a chance to fix what's going on before you go to the courts. And if you only filed a mandamus count, then arguably the government could argue that you have to let the agency, let's say USCIS, give them a chance, appeal to them, do something before you could file the lawsuit. But by including the APA claim, there's a Supreme Court case called Darby versus Cisneros, which basically stands for the proposition that under the APA, you don't have to exhaust remedies unless the statute specifically says it does. But for purposes of delay cases, with the exception of naturalization related cases, there's no exhaustion requirement really. So as long as you include that APA claim, you're foreclosing that argument on exhaustion of remedies. So even though the APA largely overlaps with mandamus, it's best to include both for these reasons. There's some technical administrative arguments that you want to prevent the government from being able to successfully make. So as always, if you have any questions, please feel free to reach out to me, and I encourage you to subscribe if this video is useful to you. Thanks.